Dear students, I am Dr. Manish Singh. I am from Dr. Ram Manohar Lohia, National Law University, Lucknow. I will be discussing a module on legal reasoning. This aims at the following learning outcomes. It aims to introduce you to the concept of legal reasoning and its importance. It helps you understand the basic components in legal reasoning. It makes you understand the role of logical reasoning in law. And it also helps you to know about the various types of legal reasoning methods in terms of kinds of arguments. Legal reasoning as a concept is a process of thinking which helps a researcher to come to decision relating to law. Law is a tool of social control that attempts to resolve conflicts in the society, to direct current activity while maintaining continuity with the past, and to control the future by laying down procedures, approaches and theories. Every decision must be guided and followed by a logical reasoning which takes into account the past decisions and statutes, the present position of the parties to the cases, and its own impact on future activity. There are four basic components in legal reasoning which applies to legal process. They are logic, justice, experience and policy. Logic refers to the internal consistency and equal application of the law. It refers to more than formal logic. Formal logic is the science of deriving a conclusion from stated premises. It is not directly concerned with either true or false. A person can obtain a false but logically correct conclusion from a false premise. Therefore, logic prefers to make correct application of precedents and equal application of law. Justice is to do right between the parties. Philosophical thought justice is an ingredient though it is based on evidence. Experience is an important component in legal reasoning. The life of the law has not been logic, it has been experience. Experience gives power to give good legal judgments. The last component is the policy. The term policy may be used to describe the process of approaching a problem. Policy is used to mean a scientific attempt to peer into the future and foresee the consequences of a decision. The use of this approach requires the individual to put aside the current interest of the parties and to keep in mind how this decision would affect other persons in future. Now we will discuss the types of logical reasoning and their principles. Among the above four components, that is logic, justice, experience and policy, logical thinking is the core concept of legal reasoning, as scientific generalizations are based on logical explanations. Every science is based on the principles of logic or reason. Science involves the rule of reasoning or use of arguments. Arguments are made on the basis of connection, relationship, association, property, common variable or attribute between things and activities mentioned in the argument. Arguments can be categorized as deductive, inductive, inverse deductive, analogy and a fortiori. Dealing them one at a time, first we will discuss the deductive method. The method of studying a phenomena by taking some assumptions and deducting conclusions from these assumptions is known as the deductive method. Deduction is a process of reasoning from the general to particular or from the universe to individual, from given premises to necessary conclusions. Deduction is also known as analytical, abstract and a priori method. It has an abstract approach to the study of science. Deductive method is a part of the scientific method. It is basically a rational approach in accordance with the tenets of deductive logic. Deductive logic uses a general statement as the basis of argument. Core of the common forms of deductive logic is syllogism. which runs like this. Plants grow in daytime. A cactus is a plant, therefore cactus plant grow in daytime. The third statement follows from the first and second statements taken together. A syllogism consists of a major premise, a minor premise, and a conclusion. A major premise usually states a general rule. In legal arguments, this is generally a statement of law. A minor premise makes a factual assertion about a particular person or thing or a group of persons or things. In legal arguments, this is usually a statement of fact. A conclusion connects the particular statement in the minor premise with the general one in the major premise and tells us how the general rule applies to the facts at hand. In legal arguments, this process is called applying the law to the facts. Taken for example, to qualify as a victim of rape under criminal law, there must be sexual intercourse with a woman. The intercourse must be without her will. This is the major premise which states a rule of law. Here the woman had consensual sex. This is the minor premise which makes a statement of fact. Therefore, the plaintiff cannot be a victim of rape under criminal law. This is the conclusion which correctly applies the law to the facts. In order for a syllogism to be valid, it must be logically impossible for its premises to be true and its conclusion to be false. In other words, a syllogism is valid if, given the truth of a premises, the conclusion follows logically such that it too must be true. An argument is not valid simply because its premises and conclusion are all true. Take this as an example. All teachers are human. Some human are excellent racers. Therefore, some teachers are excellent racers. If read apart, each of these statements is true. Teachers are indeed human. Some human, for example athletes, are excellent racers. And as it happens, some teachers are also good racers. But this argument is not valid. The fact that teachers are humans and that some humans are excellent racers does not prove anything about the racing ability of teachers. Based on the information we are given in the premises, it is logically possible that no teacher of the world has ever stepped foot in field for running. Because it is logically possible for the premises to be true and the conclusion to be false, this argument is not logically valid. The example given above is a fallacious argument. When researchers propose a study of the causal factors of the delinquencies which are on the increase and which seems injurious to them, they have some general anticipatory idea as to what to be observed and what specific facts in the main would be relevant to their inquiry, even though they may not have realized these implications. Then, on the basis of their observation, they formulate certain single propositions as to the causal factors of delinquency. That is, they deduce from the complexities of observed behavior certain single idea. In other words, they use a process of reasoning about the whole observed situations in order to arrive at a particular idea. This process of reasoning is called deduction or deductive reasoning. The following example can be cited for the deductive reasoning. Cesare Lombroso, an Italian criminologist and founder of the Italian school of positivist criminology, observed peculiar physical features among the criminals and by using the logical deductive thinking formulated the following propositions by taking his observations into consideration. Criminals are by birth a distinct type of persons. They can be recognized by stigma or anomalies such as asymmetrical cranium, long lower jaw, flattened nose, scanty beard, and low sensitivity to pains. These physical anomalies identify the personality which is predisposed to criminal behavior. And lastly, such persons cannot refrain from committing crime unless the circumstances of life are generally favored.